Mr. Beecham.
Thank you, Mr. Chair. The next proposed final rule amendments are for number 2 and number 3. Number 2 is repeal of the current Rule 217.7. Proposed final amendment number 3 is the new Rule 217.7. I do want to add a clarification on 217.7 as written, A8. We want to put a clarification in here. There's a discussion during the last commission meeting for, as it read, as we proposed it, for a person's initial appointment or for a license with more than 180 days since their last appointment or graduation from the basic peace officer course. We would like to clarify the language in the final amendment to reflect that which was approved during discussion, which would reflect, now read the last portion of the sentence, or graduation from a basic licensing course. As a result, removing the word peace officer, those two words, and replace with licensing to reflect the discussion prior to the motion. Those proposed final amendment 2 and 3 for your consideration.
Commissioners?
Mr. Chairman.
Commissioner Hester?
Counselor, subsection C shall make the person's employment records available. I know we have a lot of confusion on some of that, so G3 things or G3 file or whatever they call it, is there a time for us to clarify that, or are we good with how it is? That's basically my question from y'all's perspective, from staff perspective.
We have successfully so far taken the interpretation of this that this supersedes the other sections, and we have been telling agencies the 3G file is to be released to subsequent agencies that are trying to hire somebody, and I don't know that it's been an ongoing problem. I think that it's working for us pretty well. I'm open to it.
I just wanted y'all's input on that before we
I don't know where the disagreement comes out, or the misunderstanding or conflict comes out, is the 2 points of law seem to conflict with each other.
Correct.
And changing the rule here isn't going to adjust that or fix that issue. It may clarify what our interpretation of that law is, and if at the commissioner's desire, we could do that without a problem. We've taken that stand anyway, and
Okay.
it's been working, but if you feel like we need to, we can do that.
And just to follow up with what the executive director said, Commissioner, we have a letter that we send to agencies if this issue comes up, which gives them our interpretation of the provisions under the local government code and 1701, which in so all the cases so far is provide the clarity as to their responsibilities in regard to those files under 1701 and the difference between those responsibilities for those files under Chapter 143.
Thank you. Mr. Chairman, I make a motion to approve final amendment number 3 with the changes discussed by General Counsel.
What about 2?
I'm sorry.
Just to repeal.
And approve amendment 2 and 3 with the changes.
Second. Have a motion and a second. Any further questions or discussion?
Just a question, Mr. Chair. Kim, John, when we look at this rule, the first question I guess I had was, and I know I might have asked you already, Kim, it talks about obtaining a computerized criminal history check, to TCIC and NCIC. Is that a law enforcement agency that's getting ready to license or appoint an officer? How about the fast fingerprints that they have to be fingerprinted? They're not required to have to be ensured that that person that they're going to appoint has already gone through that, or how does that work?
Where we are on that whole situation is that technology has brought us to the point, and DPS has really moved us forward in that by moving toward a requirement of FAST that is used for the vast majority now and gets those fingerprints in a digital format. Once those fingerprints we have digitally, once they're in the system digitally like that, we really don't need to come back and re-fingerprint again What we were running into is people that did change or move around very much at all. They were having to do all these fingerprints in all these different places, and it was redundant because those fingerprints are already on file. So since we have a digital fingerprint on them, all the subsequent agency has to do is subscribe to that person with FAST, and they automatically get, instead of sending in a whole new set, they just subscribe to it. They get a report anytime something pops up on that criminal history with that person. We get a report, they get a report, and they're notified anyway. So it turned out to be fairly redundant and was causing undue work on agencies, subsequent agencies, and the fingerprinting done. There will be occasional incidents where there is another set of fingerprints done, and we feel like we can handle that on a case-by-case basis. But for the most part, the way the system should work with technology the way it is now, that was not a needed step, and so we're just taking that one step out for agency's sake.
So if you come and audit my agency and I just hired somebody and hired somebody, you're not gonna ask me for where's the copy of that you went onto the system, to the FAST system, and pulled out the document?
I'm not sure exactly what you'd ask for.
Yeah, Commissioner, so what we're going to do is at the L1 level, at the acceptance level of the L1 for the first time, we're going to ensure that the commission is subscribed. At that point, if you would like to subscribe to them, that will be an option for you, but it won't be an enforceable audit item that we're going to look at.
The bottom line, since we're subscribing to it automatically and we get the results, if that officer or that licensee gets arrested, subsequently gets arrested, we're gonna get flagged on it immediately and we will take action. And even if like it happens in many instances, the chief administrator is not aware that arrest took place, we're gonna know about it and we're gonna initiate our process, and if they didn't know about it, we're gonna help them with that, so.
And the comments that Commissioner Heston brought about the G file on, I believe it was C, just talking about making the records available. It's not speaking about, well, you have to give them copies of records where somebody can walk out of your office with a copy of a G file.
Yes, sir. No, sir. And the way the law is set up, statute is set up on that is just make it available, which I know can be problematic if you're in the Panhandle and you're trying to hire somebody that worked in Jasper, Texas, or somewhere in the Coastal Bend. You may not have the resources to send somebody down to look at those records, but it is still going to be incumbent upon you to do that background. So it's not a perfect remedy, the way this is set up, but it's probably the safest remedy for people's history and that those records aren't just floating around somewhere, but it does make them available and doesn't make them send them out.
Okay, I have a motion and a second. Is there any other questions or discussion? All those in favor say aye. Aye. Opposed, same sign. Motion carries. Mr. Beecham, final amendment number 4.
Commissioners, we have proposed final amendment number 4. This is the change to Rule 223.15. Specifically, this rule was amended to conform with the current revocation rule. This rule, as written, will remove the 1-year suspension for third-time noncompliance. As I stated, the revocation rule currently says third-time noncompliance equals revocation now. As a result, we've made this change in order to have the suspension and the revocation rule harmonize with each other. Proposed amendment number 4 for your consideration.
Motion.
Move for approval.
Second.
Have a motion and a second. Any discussion or questions? All those in favor say aye. Aye. Opposed, same sign. Motion carries. Mr. Beecham, final amendment number 5.
Final amendment number 5, Commissioners, as discussed last time, was in response to recent litigation. You'll see through the proposed language allows the executive director to issue orders of summary suspensions in very specific cases, sexual offenses, assaultive offenses. This is for felony arrest, and offenses class classified under Chapter 39 or Section 31.03F of the Penal Code. It removes subsection E, the discretionary factors in determining whether or not a offense, a criminal, a felony arrest directly relates to the duties and responsibilities of a peace officer, jailer, telecommunicator, and also removes subsection E, additional additions to subsection D. Summary of final amendment number 5 for your consideration.
Motion and second, then discussion.
Make a motion to approve amendment number 5.
Second.
Have a motion and a second. We'll have discussion if there's any other questions. All those in favor say aye.
Aye.
Opposed, same sign. Motion carries. We'll move to agenda item number 9, which is discuss and take action on proceedings for revocation, suspension, and other disciplinary action. Mr. Winter.
Good morning, Commissioners. Raymond Winter from the Attorney General's Office. The individuals listed on the first page of the disciplinary actions are the default suspension orders. There are a number of officers listed here who received executive director petitions seeking the suspension of their peace officer and jailer licenses, and they failed to respond to the executive director's petition in a timely fashion, and therefore are subject to the entry of a default order suspending their licenses. These individuals begin with Oidel Agbula, and they end with David E. Garza as listed on your agenda, and we would ask that the commission enter the orders of default suspension for all of these officers and jailers.
Okay, that doesn't conform with what we have. But the beginning name is correct, but the ending name is not the same.
Johann.
Excuse me, I misspoke. The last one is
Yeah.
Johann van der Westhausen.
Heisen.
That would be the end of the first page. There's 2
Yeah.
more listed on the next page. Oh, you're right.
Those were the
The way
first
the
2 I
page
mentioned
break is
before.
kind of
Yeah.
Okay, wait a minute.
confusing.
I'm confused.
What you've got is correct.
What we have is correct?
What you have
Yes.
is correct.
Okay. Okay.
Commissioner Hollingsworth.
Okay. I move that the commission accept and adopt the recommendations of the executive director to enter a default final order as authorized under the provisions of 37 Texas Administrative Code, Section 223.3, as required under the provisions of the Occupations Code, 1701, Section 1701-501, to suspend the licenses of the list beginning with Oidel Agbula, is that
It's close.
close enough, and ending with Johann van der Weisheisen.
Second.
Have a motion and a second. Any discussion?
Just, I just want to clarify. Timothy Cox is listed down 3 times. That's only once, or was there other names supposed to be going down there?
There's 2 of them that's listed.
Most
So
of the
is that
time, when we have a licensee listed, it's, could be in it, I'll have to look at the record as to why it's listed this way, but generally that's because there were 3 different offenses.
She's nodding, yes.
Yes, that is correct. It looks
Okay.
like we have a Class A theft, a Class B theft, and a Class A DWI.
Correct. It's in the, yes, in the summary materials.
It's back here.
Okay, have a motion and a second. Any other discussion? All those in favor say aye. Opposed, same sign. Motion carries. Mr. Winter.
Commissioners, the next 2 will be hopefully a little bit smoother. These are 2 individuals who received petitions filed by the executive director to revoke their peace officer and jailer licenses. Daniel Diaz is a peace officer with Texas Parks and Wildlife Department. He failed to respond to the executive director's petition. We therefore request entry of a default order revoking his peace officer license. Similarly, David Garza was an officer with a jailer with Karnes County Correctional Center, and he also failed to respond to the executive director's petition, and we seek entry of a default order revoking his jailer's license.
Commissioner Hollingsworth.
I move that the commission accept and adopt the recommendations of the executive director to enter a default final order as authorized under the provisions of 37 Texas Administrative Code, Section 223.3, as required under the provisions of Chapter 1701, Section 1701-501, to revoke the license of Daniel Diaz and David E. Garza, correct, Garza.
Second.
Motion and a second. Any discussion? All those in favor say aye.
Aye.
Opposed, same sign. Motion carries. Mr. Winter.
Commissioners, the next four officers are officers who received notice of petitions and entered into negotiations with the executive director. And I believe Mr. Beecham would like to make this presentation.
Commissioners, these are the result, these four proposed agreed suspension orders are the results of the informal conferences. As Mr. Winter just said, the licensees had received a petition from the executive director seeking to suspend their license for a period of 10 years. The licensees came to an informal conference at the TCOL offices, met with the informal conference committee, and what you see, you will have in your backup materials the agreed suspension orders, the terms of probation for those orders. For your consideration, this is the executive director recommends the adoption of these agreed suspension orders for Felicia Aguilar, Bryant Hall, Amber Rogers, and Tatum Stallings for your consideration.
Commissioner Hollingsworth.
I move that the commission accept and adopt the recommendations of the executive director to enter a final agreed suspension order for Felicia Aguilar, Bryant Hall, Amber Rogers, and Tatum Stallings.
Second.
Have a motion and a second. Is there any discussion? All those in favor say aye.
Aye.
Opposed, same sign. Motion carries. Mr. Winter.
Commissioner, the next item for your consideration is a proposal for decision presented by the State Office of Administrative Hearings. Christopher Call was a peace officer employed by the Richmond Fire Department. Subsequent to issuance of his license, the executive director came into possession of information revealing that Mr. Call had received a deferred adjudication for a Class A misdemeanor. Prior to the time that he was licensed, he was therefore ineligible. The executive director initiated cancellation proceedings, and Mr. Call contested the cancellation. After the SOA hearing, the ALJ has recommended through his proposal for decision that the cancellation proceed, as Mr. Call was not eligible to be licensed. And we would recommend that the commission adopt the proposal for decision as recommended by the SOA ALJ and cancel the peace officer license of Christopher Call.
Thank you. Commissioner Hollingsworth.
I move that we adopt and accept the proposed decision of the administrative law judge to cancel the license of Christopher D. Call.
Second.
Motion and a second. Is there any discussion? All those in favor say aye.
Aye.
Opposed, same sign. Motion carries. Mr. Winter.
Commissioners, the remaining disciplinary matters listed on your agenda are for information only. No action is required by the commission. There are statutory suspensions for officers who received deferred adjudications for felony offenses, and as provided by law, their licenses are statutorily suspended. There are as well statutory revocations for officers who received convictions for felony offenses, and by law, their peace officer and jailer licenses are automatically revoked. In addition, there are a number of officers who voluntarily surrendered their peace officer and jailer licenses as part of plea bargains disposing of criminal offenses. And finally, there are reprimands for officers who failed to report arrests in a timely fashion as required by law, as well as officers who failed to complete their statutorily required continuing education requirements. We're available to answer any questions you might have about any of these officers, but no action is required on your part.
Any discussion or questions? We'll move to agenda item number 10. I don't have any cards from anyone to speak, but we'll receive public comment on any topic without action, even if you didn't turn a card in. If you'd like to address the commission, you may. I didn't see anybody jump. Okay, as much as we all enjoy executive sessions, we're not going to do that today. And so we are going to stand adjourned until June 8th at our next meeting. Thank you for being here today. I appreciate it.